Hi, it's Dr. Coleman, and today I'm going to be talking about freedom of speech and how that relates to school executives and some of the issues that arise from that. But stepping back for a moment, all of our school policies and laws, for that matter, come directly from the Pursuit of Happiness Clause in our Declaration of Independence. In this country, our founding fathers firmly believed that everyone should have the right to pursue happiness. There should be no barriers or gaps to that, and that is a fundamental right as an American citizen. They added also amendments. The first amendment was the freedom of religion, speech, and the press. And if I could just refer to my notes here specifically, that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise, therefore abridging the freedom of speech or the press. Now that becomes somewhat problematic in schools because and we're dealing with children and we're dealing with families in schools, even K-12. So there have been several court cases over the years. The first one involved Tinker. This was in 1965 during the Vietnam War when a student decided to wear a black armband to school and was suspended. The family challenged that all the way to the Supreme Court. And the court ruled that simply because the students came into the schoolhouse door, they didn't give up their freedom of speech rights. That stood for a long time until the Bethel case, where a student by the name of Frazier was actually giving a graduation speech that was filled with sexual innuendos. And the court went a different route on that case when they appealed. His parents appealed his freedom of speech rights, saying that because the speech was disruptive to the educational environment, that his freedom of speech would not be maintained, and there was a specific difference between a non-disruptive protest about an ongoing war versus an event where students were required to attend and you had a student making these very suggestive and graphic statements. The third case was the Hazelwood case, which involved a student newspaper where students had printed information about 3 teens who were pregnant and another student who was getting divorced. The school officials decided not to print those 2 pages. The students and parents filed a lawsuit and appealed. They lost, however, for the same reason that the student in the Bethel case lost, is it was disruptive to the educational environment and was not consistent with the school's educational mission. So in the terms of freedom of speech, about what's approved and what's okay and what's not, it really depends on the circumstances and how it affects the school's mission, purpose, and the environment.